Okay, we are live now. Okay, so greetings once again to everyone connected to us here on YouTube Live today. In yet another session of Legal Sarcasm's webinar series. We have Miss Nupur Maithani ma'am here with us today, and I personally think that no one except ma'am can be a better speaker on today's topic. That is an overview of patent laws in India. And like always, we will definitely try to conduct the webinar in bilingual terms. But in any case, be very interactive during this session and ask your queries related to the topic to ma'am, and ma'am will be very happy to answer you all. So without much ado, let me introduce ma'am to one and all. Ms. Nupur Maithani ma'am specializes in patent protection laws, enforcement laws, patent drafting, prosecution, appeals, opposition, revocation, and infringements related to patents in India. She actively represents clients before various authorities in India, including the Patent Office and Intellectual Property Appellate Board. She is a university gold medalist in microbiology, and she has been practicing in the field of patents for more than 12 years. She has also authored several articles and chapters on patents. Ma'am is currently working as a partner in Anand and Anand, prior to which she was associated with the Patent Facilitating Center, TIFAC, of the Department of Science and Technology. Moreover, she specializes in biotechnology, pharmaceuticals, and chemical patents, and also holds a publication at Oxford University Press. I must say, ma'am, that it is an honor for us to welcome you as a keynote speaker in this webinar. And I'll be highly obliged if you'll take over from now. Over to you, ma'am.
Thank you, Hemant, for the introduction. Again, without much ado, I'll just move into the topic. And before I touch upon the history or the evolution of the patent law in India for the benefit of everybody, I just want everybody to know what exactly a patent is. A patent is a legal document which protects the intellectual property rights in an invention. Now, this is giving you, a patent gives you an exclusivity in an invention. The invention could be a product or it could be a process. It is important to note that patents' rights are exclusive rights. Exclusive in the sense that they give you the right to exclude third parties who do not have the permission of the patent holder from practicing the invention, which is the acts of making, using, selling, or importing the invention in case it is a product, or in case it is a process, the act of using the process, or making, using, selling, or offering for sale or importing a product directly derived from that process. So these are exclusive rights. They are granted to the patentee to exclude third parties who do not have the permission of the patent holder from practicing the invention, but they do not give you or the patentee the right to actually practice the invention. That is what we mean by exclusive rights. They are excluding third parties. They are not giving you the permission to practice. Giving you the permission to practice or the patentee the permission to practice may actually be within the ambit of other laws. For example, if there is a patent which has been granted on a drug, then the Patent Act would prohibit third parties who do not have the permission of the patentee from manufacturing that drug or using or marketing that drug. But they wouldn't, the patent law does not give the patentee the permission to manufacture the drug, because that manufacturing and marketing of the drug falls within the ambit of another legislation, which is the Drugs and Cosmetics Act. So this is what we mean by exclusive rights. Exclusive rights आपको दूसरे लोगों को आपकी इन्वेंशन से प्रैक्टिस करने से का हक देता है, पर आपको खुद को वो इन्वेंशन प्रैक्टिस करने का हक नहीं देता, दूसरे लोगों को एक्सक्लूड करने का हक देता है. And these are territorial rights. ये territorial है because you can only, if you have a patent in India, you can enforce it only in India. आप उसको सिर्फ इंडिया में enforce कर सकते हैं, सिर्फ इंडिया में infringement claim कर सकते हैं. अपने इंडियन पैटेंट के बेसिस पे आप यूएस या यूरोप में जाके कोई भी क्लेम नहीं कर सकते. So these are territorial rights. These are two basic aspects of most of the intellectual property that we generally come across, and that is what I want you to be aware of while we are talking about patents. Now, coming to the history or the evolution of the patents law in India, जो हमारा patent law है वो 3 phases से गुजरा है. एक हमारा law था जो colonial period में था, which was under the British rule, and that was the Patents and Designs Act of 1911. Now, ये जो Patents Act था, 1911 का Act, the term of the patent in this was 16 years, and it was extensible by another 10 years if the patentee felt that they had not been adequately compensated during that 16 years period. And जो ये 1911 Act था, that was granted in favor of both products and processes. Now, slowly, once India gained independence, the lawmakers and policymakers realized that India's industry was really crippled at that point of time. And because of the strong patent protection laws that were available, particularly under the 1911 Act, India had to import even the basic of food and medicine at exorbitant prices from the outside world. Therefore, a need was felt to change the law, or to change the law in such a manner that the local industry would be able to grow and flourish. And that led to the introduction of the Patents Act of 1970. In the Patents Act of 1970, food and pharmaceutical patents were not allowed. तो कोई भी प्रोडक्ट पैटेंट दवाइयों के लिए और फूड से रिलेटेड आपको 1970 एक्ट में नहीं मिलता था. एंड द टर्म ऑफ पैटेंट वाज फर्दर रिड्यूस्ड. 16 साल से 14 साल कर दिया गया प्रोसेस पैटेंट के लिए भी जो टर्म था, और प्रोडक्ट पैटेंट के लिए इन अदर फील्ड्स वो टर्म और भी कम था, वो 7 साल कर दिया गया. So under the 1970 Act, it was seen that the local industry did manage to flourish quite a lot, and which can be particularly seen in the very strong pharmaceutical industry that we developed at that point of time. But then India entered into another phase, which was the phase of globalization. India World Trade Organization का member बना, और हमको एक global economy चाहिए थी, global market चाहिए थी, जिसके चलते हमें TRIPS agreement को sign करना था. The TRIPS agreement is the trade-related aspects of intellectual property rights. So, under the TRIPS agreement, there were certain basic requirements that the agreement laid down. कुछ basic requirements है जो हर member nation को जो कि signatory होगा WTO and TRIPS का had to comply with. And these basic requirements required you to introduce a regime which would provide both product patents as well as process patents. And it is because of this signing of the TRIPS agreement that India had to, in a phase-wise manner, through the 1999 amendment, 2002 amendment, and finally the 2005 amendment, bring into effect the present statute, which is the Patents Amendment Act of 2005. Now, the Patents Amendment Act of 2005 gives you protection for both products as well as processes. And the term of patent has been extended uniformly for all categories of patents to 20 years. जो पैटेंट टर्म है अब वो 20 साल का है, और अंडर दिस पैटेंट टर्म बेसिकली अब जो है हमारा लॉ है दैट टेक्स एडवांटेज ऑफ ऑल द फ्लेक्सिबिलिटीज दैट आर अवेलेबल अंडर द ट्रिप्स एग्रीमेंट, बिकॉज वी हैव वेरी वेल प्लेस्ड provisions for compulsory licensing. Then we have our section 3, which provides bar to patentability of certain kinds of inventions, etc. So the Patents Act of 2005, or the Amendment Act of 2005, is a direct consequence of India being a signatory to the TRIPS agreement, and that is how we've had the current law, which is formally in place for the past 15 years now. So this was just a brief history of the Patents Act. Hemant, if there are any questions at this point of time that you would want to take, otherwise I'll just proceed.
Okay, ma'am. So, ma'am, the question is, what is the procedure of registering a patent law?
Yes, so I am going to get on to it subsequently in my presentation. So let me just get on to it subsequently because it's going to get a little longish. Other than this.
Okay, ma'am. So, ma'am, there is one question that why the granting of patent in India is tougher as compared to the other nations?
I wouldn't say it is tougher as compared to other nations, but every nation has their own criteria for patentability. And as I said, the TRIPS agreement has laid down the foundation or certain basic requirements under which you have to grant a patent. For example, आपको product के लिए patent देना ही पड़ेगा, process के लिए भी patent देना ही पड़ेगा, और 3 basic requirements है जिसको comply करके आपको product या process के लिए patent मिल सकता है. वो 3 बेसिक रिक्वायरमेंट्स नोवेल्टी, इन्वेंटिव स्टेप एंड इंडस्ट्रियल यूटिलिटी है, जो कि मैं अभी आगे और बात करूंगी इसके बारे में. लेकिन इन 3 बेसिक रिक्वायरमेंट्स को अगर आप कंप्लाई करते हैं, देन यू आर एलिजिबल, यू शुड बी एलिजिबल फॉर अ पैटेंट ग्रांट in most of the nations of the world. But again, the TRIPS agreement gives you the flexibility to have certain exclusions to patentability. And in the form of these exclusions, we have our Section 3, which prohibits grants to certain category of inventions. Or basically, we don't treat those categories as inventions under Section 3 of the Patents Act. And it is primarily because of Section 3 that you will see the difference hota hai claims mein between what is granted in India और जो बाहर मिलता है आपको outside India. But then that doesn't mean that Europe, for example, doesn't have their own exclusion criteria. European law also has their own exclusion criteria. The American law has certain exclusion criteria, and this is all dependent on what each member state wanted to take up post the TRIPS agreement. It could be said that until this point of time, or until very recently, let's say around up to 3 years back or 4 years back, the grant of a patent took a little longer in India because our patent office was suffering for want of staff. हमारे पास इतने लोग नहीं थे काम करने के लिए patent office में. But then there was this massive drive pursuant to certain court orders, जिसके चलते खूब सारे examiners को appoint किया गया, 200 से ज़्यादा examiners को लिया गया. और अब जो patent process and there are a lot of provisions to expedite करने के लिए grant को या grassroots level innovation को encourage करने के लिए patent rules में डाले गए. Act को तो अभी तो 2005 के बाद amend किया है. So उसके चलते now you'll see that patents are also granted at a very speedy rate in India. So I wouldn't say that it's very, very difficult to get a patent in India. No, it is not. It could have taken a lot of time in the past, and then there are certain issues like 3D, जो कि हमेशा रहेंगे. And we've also seen the Novartis battle that has gone on for so long. जिसके चलते थोड़े narrow criteria बन गए हैं, but that doesn't mean it's difficult. It's still doable, and it is. And patents are very much granted in India, and at a much faster rate now as compared to the past.
Okay, ma'am. So, ma'am, you may continue with your presentation.
All right.
Yes.
Okay. So, under the current patents regime, we'll see that there are 3 bodies primarily where we deal with our patents. So, yes. So, we have the Patent Office, which is the primary body where the prosecution of a patent takes place. That is, you file an application at the Patent Office. The Patent Office. So here I come to also the procedure of grant of a patent application. So the first step is when you have an invention in hand, a patent attorney is going to draft that invention into a patent. The patent is basically going to be a body, or it's basically a document where the entire invention is explained, and it is going to end in claims. Now, the claims are the real part which defines the invention for which you are claiming monopoly. जिसके लिए आप मोनोपोली लेना चाहते हैं, वो आपके क्लेम से डिटरमिन होता है, आपकी स्पेसिफिकेशन से नहीं, जिसमें बहुत सारी चीजें हो सकती हैं. उसमें प्रायर आर्ट भी हो सकती है, उसमें आपने इन्वेंशन को समझाने के लिए बहुत सारी ऐसी बातें भी बोली हो सकती हैं जो कि आपकी मोनोपोली से इतना लेना देना ना हो, पर आपका जो मोनोपोली है या स्कोप है प्रोटेक्शन का, वो आपके क्लेम्स से देखा जाता है. So a patent always has to end with a set of claims which defines what exactly is it that for which you are trying to claim protection. So once you have drafted this document, which is called as a patent, you file it at the Patent Office. The Patent Office then, and you get a filing date for filing of your application. The Patent Office publishes your application within 18 months from this date, the filing date or the earliest filing date, which is called as a priority date. So your patent is going to be, your application is going to be published after 18 months. 18 महीने के बाद वो publish होगी. जब वो publish हो जाएगी, इसके 2 consequences होते हैं. One, आपकी invention अब public domain में आ जाएगी. In the sense कि अगर किसी को आपकी invention के बारे में जानना है, वो patent office में application डालकर आपकी invention के details ले सकता है. दूसरा, अगर कभी future में आपको patent grant हुआ और आप इन्फ्रिंजमेंट के लिए सू करते हैं किसी थर्ड पार्टी को, तो आपके डैमेजेस जो हैं वो आपकी डेट ऑफ पब्लिकेशन ऑफ एप्लीकेशन से डिटरमिन होते हैं. सो योर डेट ऑफ पब्लिकेशन इफेक्टिवली मार्क्स द डेट ऑन विच योर इन्वेंशन वाज कम्युनिकेटेड टू द वर्ल्ड, एंड द वर्ल्ड केम टू नो, ओके, देयर इज समबडी कॉल्ड पर्सन X who has filed for an application of patent, and we should not touch this invention lest a patent be granted. क्योंकि अगर इस इन्वेंशन पे पैटेंट ग्रांट होता है तो बाद में ये पर्सन एक्स हमें हमारे इस इन्वेंशन को प्रैक्टिस करने के लिए सू कर सकता है. So basically, your publication date is important because it is a communication date to the world regarding your invention. इससे पहले आपका इन्वेंशन बेसिकली एक सीक्रेट एरिया में है क्योंकि nobody knows about its existence and nobody can ask for the patent office about it. उससे पहले आप अपनी एप्लीकेशन को विड्रॉ भी कर सकते हैं. अगर आपने विड्रॉ कर लिया तो वो कभी पब्लिश नहीं होगी, और अगर पब्लिश नहीं हुई तो ऐसे देयर इज गोइंग टू बी नो पब्लिक नोटिस ऑफ योर इन्वेंशन. सो वन इज पब्लिकेशन. आफ्टर पब्लिकेशन, सब्जेक्ट टू द फाइलिंग ऑफ ए रिक्वेस्ट फॉर एग्जामिनेशन, आपको एक रिक्वेस्ट फॉर एग्जामिनेशन भी फाइल करनी होती है फॉर योर पैटेंट एप्लीकेशन, और वो रिक्वेस्ट फॉर एग्जामिनेशन 48 मंथ्स के अंदर फाइल करनी होती है फ्रॉम द अर्लीस्ट डेट ऑफ फाइलिंग ऑफ द एप्लीकेशन. If the applicant has filed a request for examination, then the patent is going to be taken up for an examination. When the patent is taken up for an examination, the controllers and examiners at the patent office, they examine your invention for 3 criteria primarily. One is novelty. Novelty means that your invention should not have been published anywhere in the world. आपके इन्वेंशन के बारे में कोई जानकारी किसी भी डॉक्यूमेंट में नहीं होनी चाहिए. अगर कोई भी एक भी ऐसा डॉक्यूमेंट मिल गया जिसमें आपके इन्वेंशन के सारे फीचर्स हैं तो आपकी इन्वेंशन नॉवेल नहीं रहेगी और वो पैटेंट के लायक नहीं बचेगी. सो नॉवेल्टी इज अ वेरी इंपॉर्टेंट क्राइटेरिया फॉर यू टू गेट a patent on your invention, and it means that your invention should not have been published anywhere in the entire world or used. So now, when I say or used, now use is a criteria which there is a dichotomy in the act, and I would say this is something unharmonious in the act because it's not very clear whether it is used in India only or used throughout the world. If you see section 2(1)(l) of the Patents Act, that talks of a new invention. It says a new invention is an invention which has not been published anywhere in the world or used anywhere in the world. But when it comes to the criteria for challenging the validity of a patent, which is under Section 25, which is oppositions, and Section 64, which is a revocation, the criteria is restricted to use in India. So your invention should not have been published anywhere in the world, but for a validity challenge, it should also not have been used, at least in India. So these are the criteria. It should not have, this is a novelty criteria where your invention should not have been published anywhere in the world or used. Second is the inventive step criteria. Inventive step criteria means that your invention should not have been obvious to a person skilled in the art. Obvious मतलब कि it should not be, आपको 2-3 डॉक्यूमेंट्स पढ़ने के बाद ऐसा नहीं लगना चाहिए ओ अगर मैं इन 3 डॉक्यूमेंट्स को आराम से पढ़ता तो मैं इस इन्वेंशन पे आराम से पहुंच जाता या पहुंच जाती. तो वो इन्वेंशन ऑब्वियस है. इफ यू फील दैट देयर वाज नो mental challenge in arriving at the invention upon reading those few documents, or it would have been very, very obvious for a person skilled in the art to arrive at that invention, then your invention is lacking in a criteria called as inventive step, for which it is liable to be challenged and not granted a patent. So your invention should be novel, it should be inventive, and it should also be capable of industrial application. So it should be capable of being made or used in the industry. It should not be a mere, a mere mental act or something like that, something which has only theoretical benefits. It should be something which is capable of being made or used in the industry. So उसमें utility होनी चाहिए. These are the 3 basic criteria for patentability, which the patent office is going to test your invention on. They are going to search through a variety of literature, and then upon searching through that literature, if they find there are documents which are killing the novelty or inventive step of your invention, or another ground that they are going to look into is whether your invention is patentable as per the criteria of Section 3 of the Patents Act. And I'm going to get back to Section 3 in greater details once I complete this procedural part. So the Patent Office is going to examine your invention or novelty, inventive step, industrial utility, and non-patentability criteria, and they are going to issue a report holding whether your invention is patentable or not. That report is sent to the applicant, and the report is called a first examination report. Upon receipt of the first examination report, the applicant is supposed to file a reply within 6 months from the receipt of the first examination report. In their reply, they are supposed to tell the patent office how their invention is new, how it is inventive. If they require to make any changes in the claim to make the claims new and inventive, they will also make those changes in the claims or amendments in the claims. And after that, you are supposed to file a response within 6 months. This period is also extensible by another 3 months, so maximum of 9 months. After you have filed a reply, the patent office is again going to consider your case and see that in light of your response, do they change their opinion? If they do not change their opinion, they are going to issue a hearing notice to you where they would require to appear before you, before the patent office, and convince them orally through arguments regarding the patentability of the invention. If they are convinced with your invention based on your response to the first examination report, they are going to grant the patent. If they are not convinced, of course, you get a hearing, you appear before the controller, argue your case. If the controller is satisfied then with your case, the patent is granted. Otherwise, it is refused. Now, if a patent is granted, it is going to be published. Again, so this is the second level of publication. The first was when your application was published. Now is when your patent grant is published. Once your patent grant is published, your period for post-grant opposition starts running. So the post-grant opposition period is 12 months from the date of publication of grant of your patent. So, I'm sorry, but I did not touch on the pre-grant opposition. The period for running of the pre-grant opposition is from the date of publication of your application till any time before grant of the patent is the period when any person can file a pre-grant opposition. So India has these the system of challenges to the grant of a patent, and once a patent has been granted, a challenge to the very existence of the patent through oppositions and revocations. So once your patent is granted, it is published, and upon publication, of course, your limitation period for post-grant opposition starts running. If it is refused, there is another body where you can go, which is called as the Intellectual Property Appellate Board. So for all practical purposes, upon refusal of your application, your prosecution at the patent office is over. आपका patent office stage खत्म हो गया upon refusal of your application. अगर आपको इसको challenge करना है, तो आप एक appeal file कर सकते हैं Intellectual Property Appellate Board पे. So this is another body which exists under the Patents Act. So we have the patent office at the first instance where you file a case and you prosecute your application, leading to either a grant or a refusal of the application. And then there's another body called the Intellectual Property Appellate Board where you challenge all the orders of the controllers, particularly under Section 14 and 15 and under Section 25 at the Intellectual Property Appellate Board. And final jo aapki body hai where your enforcement of the patent is going to take place is the court. So basically the patent granting authority is the patent office. Challenges are thrown at the Intellectual Property Appellate Board level. Also, the Intellectual Property Appellate Board takes care of revocation challenges that are filed against a patent or validity challenges to a patent that are filed at the Intellectual Property Appellate Board. And then you have the courts of India, basically the district courts and the high courts, where you can, which are the enforcement authorities, where you can file suits for infringement of your patent. Now, this is so far as your infringement authorities are concerned. The authorities under the Patents Act are concerned. Now, yes. So, as I told you, I touched upon the criteria for patentability being novelty, inventive step, and industrial application. I also mentioned that there are certain criteria or certain exclusions to patentability in India, which are provided under Section 3. Section 3 ऐसी चीजों को enlist करता है जिनको हम इंडिया में invention treat नहीं करते हैं. तो इसमें बहुत सारे there are up to like around JK तक जाते हैं जो objections हैं. पर जैसे अगर कोई invention है which is contrary to well established natural laws, वो इंडिया में patentable नहीं है. Then if there is any invention which is against public order or morality. For example, if there is something which is encouraging, if there is an invention which is teaching you a method of drug abuse, then that method of drug abuse will not be patentable in India because it is against public order and morality. So anything that is against public order or morality, or any invention which is prejudicial to plant, animal, or human life or health is not patentable. Then discovery of any living or non-living thing occurring in nature. अगर कोई भी नेचर में केमिकल है जिसको आपने खोजा, जो एग्जिस्ट करता था, जिसके बारे में पहले दुनिया को नहीं पता था, पर आपने बस अब उसको ढूंढ निकाला कि ये भी कोई एक चीज है, ये एक नया मेटल है जो ऑलरेडी नेचर में था, उसके लिए इन्वेंशन नहीं, आपको पैटर्न नहीं मिलेगा, उसको इन्वेंशन नहीं ट्रीट किया जाता बिकॉज दैट वाज ऑलरेडी इन नेचर. Then there is the very popular Section 3D, which prohibits grant of a patent to a new use of a known substance, a new form of a known substance, or a mere use of a known method. इसका मतलब ये है, like for example in the present coronavirus context, अगर कोई एक दवाई थी जिसको खांसी जुकाम ट्रीट करने के लिए यूज किया जा रहा था, आज कोई आके कहता है कि इस दवाई को या इस केमिकल कंपाउंड को हम कोरोना वायरस इन्फेक्शन ट्रीट करने के लिए भी यूज कर सकते हैं, तो ये उसका न्यू यूज है, एक एग्जिस्टिंग दवाई का न्यू यूज है. ये न्यू यूज पैटेंटेबल नहीं है. अंडर सेक्शन 3D of the Patents Act in India, this kind of new use is not allowed. Secondly, अगर कोई न्यू फॉर्म है उसी सब्सटेंस का, for example in chemistry there are a lot of compounds, and each compound can exhibit a specific polymorphic shape. For example, कोई कंपाउंड है जो एक क्रिस्टल फॉर्म में होगा, एक दूसरे क्रिस्टल फॉर्म में होगा, उसके सॉल्ट्स एक्सेट्रा, ये सब पैटेंटेबल नहीं है अनलेस आप दिखाओ कि ये जो नए फॉर्म्स हैं उस एग्जिस्टिंग केमिकल कंपाउंड के, वो कुछ इम्प्रूवमेंट शो करते हैं एफिकेसी में, अपनी ट्रीटमेंट स्ट्रेंथ में वो कोई इम्प्रूवमेंट शो करते हैं, या वो सेफ्टी में कुछ इम्प्रूवमेंट शो करते हैं, तब तक वो आपको ग्रांट नहीं होंगे. फिर अगर कोई नोन मेथड है जो ऑलरेडी किसी काम के लिए यूज हो रहा था, आज आपने उसको किसी नए काम पे लगा दिया, वो भी पेटेंटेबल नहीं है.
Ma'am, actually, I wanted to interrupt you and ask a question on that.
Sure.
So, ma'am, in the case of Novartis AG versus Union of India, Supreme Court had a certain percentage of efficacy. That if there is an increase of certain percent of efficacy, then it can be patentable. So, how does the efficacy is calculated, and it can is it not possible that the companies can manipulate that percentage of that efficacy?
Okay. So, firstly, Hemant, Novartis case did not rule on any percentage of efficacy. The question before the Supreme Court in the Novartis case was whether the improvement in bioavailability of imatinib mesylate beta crystalline form amounted to an improvement in efficacy. So these are two scientific terms here which were before the court. Bioavailability is improvement in availability of a compound inside the body. So court जानना चाह रहा था कि this improvement in availability, is it equivalent to efficacy? Is it equivalent to an improved efficacy of the drug? And the court ruled that probably in the case of imatinib mesylate beta crystalline form, that improvement in bioavailability was because of the improvement in physical forms or physical properties of the compound, and it had nothing to do with efficacy. So the court narrowed down the meaning of efficacy within Section 3D to therapeutic efficacy. कि बॉडी में ऐसे नहीं है कि सिर्फ अवेलेबिलिटी बढ़ गई कंपाउंड की, कुछ थेरेप्यूटिक इफेक्ट होना चाहिए बॉडी में. बट एट द सेम टाइम द कोर्ट ऑल्सो left a lot of criteria moot. For example, उन्होंने सेफ्टी पर उन्होंने नोट किया कि अगर improved safety होती है, so it's better. The compound is definitely better if it is safer as compared to the prior art compound. But they did not rule on that. They did not touch on that because they felt that for the particular case at hand, at least जो bioavailability थी, वो therapeutic efficacy को contribute नहीं कर रही थी. That is why they said that under Section 3D, you have to show therapeutic efficacy. It cannot be like physical improvement in physical properties. The compound has become more stable, etc., etc. That is not going to help. You need to have a compound which shows therapeutic efficacy.
So, ma'am, do you think, ma'am, these kind of the Section 3D specifically talking about? So, ma'am, do you think in any way it is restricting the growth of pharmaceutical companies?
See, again, that's a very subjective issue. It cannot be answered in yes or a no. But I do know one thing for sure, that when you talk of therapeutic efficacy only, then to a certain extent, we are barring a certain kind of patent applications in India. For example, we do not grant patent applications where we have a new compound or a new form of a known compound which shows other improvements, for example, improved physical properties, which may be very important for the manufacture of that compound, right? It may not be creating an extraordinary effect inside the body, but at the same time, it is showing very important aspects when it comes to manufacture. So we are clearly not granting such patents because of Section 3D. Whether it is really hampering the growth of pharmaceutical industry in India or not is again a very subjective issue, and a lot of data on that needs to be collated. It cannot be answered in a straight yes or no. But at the same time, if you look at our own indigenous pharmaceutical industry, we do mostly a lot of secondary inventions. So maybe at the end of the day, the indigenous pharmaceutical industry suffers more because they are not able to obtain patents for their secondary inventions, which do not show therapeutic efficacy. But then at the same time, even with the Supreme Court decision in Novartis, it is not like bioavailability altogether has been ruled out as a criteria for improved therapeutic efficacy. It is again a subjective issue. If you come up with a case where you can show that this improvement in bioavailability is leading to an improved therapeutic efficacy, that case may probably be granted in the future. So it is subjective. Yeah. So can I proceed, or do you have
Sure, ma'am. Sure, ma'am. Sure, ma'am.
Yeah. So yes. So then there's, other than Section 3D, there is another section which is called a Section 3E, which prohibits the grant of a patent to mere admixtures. Mere admixtures हुए कि अगर आपके पास एक compound था A जो arthritis के treatment में use हो रहा था, और दूसरा compound B जो pain treatment में use हो रहा था, और आपने इन दोनों compounds को एक दवाई में डाल दिया, और उस दवाई का असर यही रहा कि अभी भी A आर्थराइटिस को ट्रीट कर रहा है और बी पेन को ट्रीट कर रहा है, तो इसको एडमिक्सचर कहते हैं कि उसमें कोई ऐसा बदलाव नहीं आया जो कि उसको पेटेंटेबल बना दे, क्योंकि ए आर्थराइटिस करता था, बी पेन करता था, आपने दोनों को एक साथ डाल दिया, कोई इंप्रूवमेंट नहीं है. पर अगर आपने दोनों को एक साथ मिलाया एंड यू गेट अ मेडिसिन which instead now treats headache, for example, instead of knee ache, then it is a super additive effect and it's called a synergy. So then your invention qualifies for a patent. Similarly, mere arrangement or rearrangement of known devices, ये patentable नहीं है. Method of agriculture patentable नहीं है. अगर कोई method of treatment है, diagnosis है, ये सब patentable नहीं है. तो आज अगर COVID-19 सिनेरियो में इतने सारे diagnostic kits आ रहे हैं, तो कोई बोले कि मैं एक diagnosis का तरीका patent करना चाहता हूँ या method of diagnosis patent करना चाहता हूँ, they are not going to get a patent in India. They may get a patent elsewhere, but not in India, because it's a method of diagnosis or a method of treatment. Then plants and animals are not granted a patent in India. Other than microorganism, nothing else is granted a patent so far as living beings are concerned. Then mathematical or business methods and computer programs per se are not granted inventions. अगर आपका computer program कोई technical effect नहीं show करता है, you have to show a technical effect. If your computer program is a mere literary program which is resulting in a theoretical effect, it is not patentable. It, of course, can be subject to the copyright legislation where you can go and get a copyright on your algorithm. But if your computer program creates a technical effect, for example, if there is a computer program which is helping you to monitor the temperature in an industrial process and to regulate that temperature, then that program is very much patentable because there is a technical effect here. इससे कोई आपको technical effect मिल रहा है, आप एक पूरे industrial process को monitor और regulate कर रहे हो. So such computer programs are patentable, but if it is only some theoretical advantage that you're getting, of course it's not patentable. Then literary, dramatic, musical or artistic works or any other aesthetic creations which are within the ambit of the Copyrights Act are not patentable. Mere scheme, rule or method of performing a mental act or playing a game is not patentable. A presentation of information is not patentable. Topography of integrated circuits are not patentable. And traditional knowledge is also not patentable. So these are the things which are not patentable in India. Other than this, we have Section 4. Section 4 defines inventions which are not patentable. The difference between Section 3 and Section 4 is Section 3 defines certain criteria or certain categories of which are not treated as inventions. So they are not treated as inventions altogether. But Section 4 defines inventions which are not patentable. According to Section 4, any invention which falls within the ambit of Section 21 of the Atomic Energy Act will not be granted a patent in India. So these are they are treated as inventions, but nevertheless they are not granted a patent if they fall within Section 21 of the Atomic Energy Act. Hemant, do you have any questions, or should I just proceed?
No, ma'am, you may proceed now.
Okay. Yeah. So when now I am on the Section 4 inventions not treated as patentable, which is the atomic energy inventions. If the controller feels that upon examination of your application that your invention relates to atomic energy, which is production, control, use or disposal of atomic energy, or the mining, extraction, etc. of radioactive substances, or any method which is ensuring safety in an atomic energy operation, if the controller feels that your invention relates to atomic energy, he is going to communicate that I am raising an objection under Section 4 of the Act on your invention to the applicant, and at the same time, the application is referred to the Department of Atomic Energy. The applicant can file his submissions before the Department of Atomic Energy as to why his invention is not relevant for the purposes of Section 21 of the Atomic Energy. The Department of Atomic Energy then analyzes your application in light of your submissions, and they may either refuse or allow your application. If they allow the application to proceed, the Patent Office will continue with its regular examination. But if they do not allow your application, then your application is gone at that point of time itself, because this is an exclusion criteria, and you will never be granted a patent for any invention that is falling within Section 21 of the Atomic Energy Act. Now, this brings me to another provision, because these are sort of related to defense and security of the nation. So this brings me to another provision at the same time, which is called as Section 35 of the Patents Act, which are secrecy directions. Now, if the central government or the controller of patency feels that the invention relates to certain group of criteria which have been notified by the central government as relevant to the defense of the country, the controller will restrict the publication of information in relation to such an application and is going to refer the case to the central government. The central government is going to review the case and is either going to maintain the objection of the controller or is going to waive the restriction. Now, in case the central government waives the restriction, आपकी invention publish हो जाएगी, उससे related information public में आ जाएगी. But अगर central government इस objection को maintain करके रखती है कि आपकी invention defense purposes के लिए important है इंडिया के, तो जो publication वाला hindrance है वो हमेशा रहेगा. Your invention is not going to get published. The applicant can, however, request the central government to reconsider the scenario. They can ask the central government कि एक बार दोबारा से देखा जाए, क्योंकि हो सकता है कि उनकी invention defense purposes के लिए no longer relevant हो. And then again, of course, the discretion is of the central government to decide on whether your invention still falls under the prohibitory criteria or not. But even if the secrecy directions are imposed under Section 35, and though there are restrictions to the publication of your application and patent, आपका जो normal prosecution procedure है वो चलता रहेगा. आपका patent grant भी हो सकता है, but again at the same time your grant is not going to be published. So this is one unique criteria, which is the secrecy directions. Then there is another criteria for people who are residents in India or inventors who are residents in India. This is Section 39 of the Patents Act. Indian residents cannot apply for patenting of an invention outside India without seeking prior permission. तो अगर आप एक इंडियन रेजिडेंट इन्वेंटर हैं, आपको सबसे पहले इंडिया में ही फाइल करना पड़ेगा. 6 हफ्तों तक इंतजार करना पड़ेगा बिफोर यू प्रोसीड विद फाइलिंग ऑफ योर एप्लीकेशन आउटसाइड इंडिया. बट if you do not want to file in India first, you do not want to wait for 6 weeks before proceeding to file outside India, then you can seek prior permission from the Patent Office for filing of your application outside India. So these are all all sections which have been brought into the Act in view of the criticality of defense and certain inventions in the defense field already. Okay.
Yes, ma'am.
So, Hemant, do you have any questions?
Yes, ma'am. So, ma'am, basically, a person has asked, can you please highlight the concept of compulsory license and its relevancy in accordance with Indian patent law?
Yes, sure. So, should I directly jump to compulsory licensing? Okay, I'll do that. Yes. So, that was actually the next section of my talk. Um, as I said, the TRIPS agreement lays down the basic foundation for what every nation's jurisdiction should have in their patents law, all those nations who are members of the TRIPS agreement. And beyond that, they've given you a certain limit of flexibility to, preserve your own national interests. And in consonance with that, India has a compulsory licensing regime too, and we have three types of compulsory licenses primarily, which are granted in India. The first kind of compulsory license is under Section 84 of the Patents Act. So, in this compulsory licensing provision under Section 84, there are certain criteria that need to be satisfied. The first is, when can you file such a compulsory licensing application? Under Section 84, the compulsory licensing application can be filed after 3 years of grant of the patent, not before that. Who can file? Any person interested can file, but that person has to be a person interested. That means a person having tangible interests in the field, direct and tangible interests in the field. And what are the grounds for securing a compulsory license under Section 84? The grounds are that the reasonable requirements of the public with respect to the invention have not been met, or the invention is not available at a reasonably affordable price in India, or the invention has not been worked in India. So these are the three primary criteria based on which any person interested can, after 3 years of grant of the patent, file for a compulsory license under Section 84. In granting the compulsory license, the controller, of course, will have some consideration of the steps that have been taken by the patentee in working the invention in India. If the invention has not been worked, what were the reasons for not working, etc. And what are the efforts, what is the time that has lapsed since the grant of the patent? What is the nature of invention? Maybe the invention is very, very complex and it requires time to be executed in India. Maybe it requires thousands of other approvals under other laws. For example, if it's a drug, it cannot be directly launched in India. You need approval from the Drug Controller General of India. So that requires clinical testing, etc. So the controller is going to take into consideration all these factors before granting a compulsory license under this section, or refusing a compulsory license application under this section. So this is the first kind of compulsory licensing application, which is under Section 84 of the Act. The second compulsory licensing application is provided by Section 92, which is compulsory licensing on notification by the central government. Now, this kind of an application can be filed any time after grant of the patent. So you do not need to wait for a 3-year period to expire before filing for a compulsory licensing application here. This can be done any time after grant, provided that the central government, under conditions of national emergency, extreme urgency, public non-commercial use, or public health crisis, issues a notification giving a declaration to the effect that a compulsory licensing should be issued on a particular patent. So if the central government has issued such a notification, then only a person interested can file for such a compulsory license at the patent office. And so it is important to note that all these compulsory licensing applications are being granted at the patent office level. The notification is issued by the central government, but then a person interested has to apply to the central government. Then we have a third kind of compulsory license, which is under Section 92A, and this is called as Doha-style compulsory licensing. This kind of compulsory licensing is not for domestic use. This is available for the manufacture and export of patented pharmaceutical products. This is only for pharmaceutical products to any country having insufficient or no manufacturing capacity in the pharmaceutical sector for that product, to address public health problems, provided that a compulsory license has also been granted in the country where the export is intended to be made, or the government has by notification or otherwise expressed that they require the importation of such a patented product from India. This is when the Doha-style compulsory licensing license is going to be granted. So under each of these categories, India has seen a couple of cases. Other than, I think, the central government notification, which is the Section 92 style compulsory licensing, India has seen compulsory license applications under Section 84 and Section 92A both. Section 84 is the Bayer case in relation to sorafenib tosylate, which is the anti-cancer drug, where NATCO, I think, they had applied for a compulsory license from Bayer, and the grounds that were taken were of the drug not being available at a reasonably affordable price to the public, because the drug was priced at a very high cost, and of not the reasonable requirement of the public not being met with respect to the patented invention. And a compulsory license was granted under Section 84 to NATCO. The other case, which was Section 92A, this was the first provision of compulsory licensing that was tested in India. And I think this was way back in 2009 when Pfizer and Roche were again approached. There were applications filed by NATCO at the patent office requesting for manufacture to export into Nepal Pfizer's Sutent and Roche's erlotinib. So both of these applications were turned down by the patent office because apparently the Nepalese government had not issued a notification that there was a public health emergency, or they did not have sufficient manufacturing capacity in the field, or that they required the manufacture of the drug in India to be exported into Nepal. So these applications were turned down by the patent office, whereas the Section 84 compulsory license application by Bayer has been granted. So I hope that it answers your question, Hemant, or is it something else?
No, ma'am. It's fine. Yes.
So with that, I have also covered the compulsory licensing aspect here. Okay. Now, other than all these provisions of filing in India and having your application examined, as I touched upon cursorily in the last part of my talk, we also have a system of revocation of patents and of filing oppositions to patents. So it is not so easy, sometimes to get a patent, because India has several levels at which you can have a patent application not granted or a patent revoked. Now, the first level at which you can prevent the grant of a patent is a pre-grant opposition. Any person, it is very important to note here that any person, it could be just about anybody who does not even have tangible interests in your application, can file for an opposition against your patent application and try to hinder the grant of your patent application. There is, of course, a certain set of criteria. There are around 12 grounds which have been enlisted in Section 25 for this type of an opposition to be filed. This opposition can be filed at any time after publication of the application, but before grant of the application. And on the grounds of the invention lacking novelty, inventive step, non-patentability, insufficiency, lack of utility, etc. Not utility here, but in non-compliance with Section 8, etc. So there are several grounds on which you can file a pre-grant opposition under Section 25(1). So this would, in effect, if the application, the pre-grant opposition is allowed, in effect, it would lead to the refusal of the application and a patent will not be granted. But if the pre-grant opposition is turned down, of course, the patent will be granted. Once a patent is granted, any person interested can file a post-grant opposition under the very same grounds in which a post-grant opposition is filed. So, but the limitation period for filing of a post-grant opposition starts after the publication of the grant of the application and ends within 1 year from the date of publication of grant. So, any person interested can file the post-grant opposition. Now, both these oppositions, which are pre-grant and post-grant oppositions, are dealt with at the patent office level. Then there is another level of invalidity challenge that can be thrown at the patent, which is at the level of the Intellectual Property Appellate Board, where any person interested can, under Section 64, file for revocation of your granted patent. The grounds are slightly broader than what is provided by Section 25. And again, based on those several grounds, you have to be an interested person having valid and tangible interest in the patent. This kind of an application can be moved before the Intellectual Property Appellate Board. Another level of challenge is before the High Courts. Now, this level of challenge arises usually in a defense against an infringement suit. So, if a patentee is claiming infringement of their application and of their granted patent, at the level of the court, then the defense to the defendant available is to claim that your patent is invalid. And that is done through a counterclaim in a suit for infringement. And so this is the fourth level of challenge that can be thrown at a granted patent. And this is at the court level. I'm not sure if I have touched this, but the term of patent in India is 20 years. As I said, the patent rights are exclusive rights. So if your invention is in a product, it gives you the exclusive right to prevent third parties from making, using, selling, offering for sale, or importing the product into India. If the granted invention is a process, then it gives you the exclusive right to prevent third parties from using the process or making, using, selling, or offering for sale or importing the product directly obtained from that process. A patent, of course, also has to be maintained by the payment of renewal fee, and you have to file annual working statements with regard to the patent. Now, what can you do once you have a patent in your hand? You can enforce it by preventing other people from practicing your invention. You can sell it or assign it to any third party at a cost. A patent can also be licensed. And there are various kinds of licensing agreements that you can enter into. You could have an exclusive license, a non-exclusive license, and you can end up cross-licensing your application too. That means you're exchanging licenses. आपने अपना patent license किया और दूसरी party से उनके patent पे license लिया. So you can enter into a number of negotiations and arrangements based on your patent. And so that is what is actually giving you commercial value for your patent. Preventing third parties from practicing your invention, being able to sell your intellectual property, and being able to license your intellectual property in exchange of a certain royalty adds value to your patent. Hemant, are there any questions, or should I just proceed?
Ma'am, actually, we are having many questions which are non-technical. So it's like I think we should entertain those questions in the last, because it will just interrupt the whole flow of the webinar. So ma'am, you may continue.
All right. So with this, I'll get to the last part of my talk, which is regarding enforcement of patents and where exactly you can, or what exactly you do when you enforce your patent. Now, whenever there is any proof of infringement in the hands of a patentee, they can file a suit for infringement. Now, the suit for infringement can be instituted. The lowest level court in this case is going to be a district court or a high court. So there are at least six high courts which have original jurisdictions, civil jurisdictions for entertaining patent lawsuits. These are the high courts in Delhi, Bombay, Calcutta, Madras, Jammu and Kashmir, and Himachal Pradesh. So you can file infringement suits in before either the district court or the high court. And if, however, as a defense to your infringement suit, the defendant files a counterclaim for invalidity of your patent. अगर defendant कहता है कि ये suit valid नहीं है क्योंकि इनका patent ही valid नहीं है, which is a counterclaim for invalidity, तो if such a suit has been filed before the district court, it will have to be transferred to the high court. It cannot stay before the district court. So in case there is an invalidity or a challenge to the validity of the patent, the suit has to be transferred to the High Court. Now, there has been this Commercial Courts Act, the introduction of the Commercial Courts Act in 2015, through which certain changes have been made in the scenario. And now it's not like any district court can entertain a patent lawsuit, particularly if the High Court, under whose jurisdiction the district court is, has a commercial court division, then you cannot file a lawsuit in a district court, a patent infringement lawsuit in a district court. So, for example, in Delhi, we have a commercial court division in the Delhi High Court. तो अब आप दिल्ली डिस्ट्रिक्ट कोर्ट में नहीं फाइल करेंगे, दिल्ली के डिस्ट्रिक्ट कोर्ट्स में नहीं फाइल करेंगे, आप हाई कोर्ट में infringement suit फाइल करेंगे. Now, what is the burden of proof in filing an infringement suit? The burden of proof is split. If it is a product patent, अगर आपका patent product पर है, तो burden of proof to establish infringement is on the party alleging infringement, that is the patentee or the plaintiff. तो plaintiff establish करेगा कि defendant का product जो है वो infringe करता है उनके patent को. पर अगर जो patented सब्जेक्ट है वो एक प्रोसेस है. If it is a process, then the burden of proof shifts. The burden of proof shifts on the defendant, provided that the patentee shows that the subject matter of the patent is a process which is resulting in a new product, or that there's a substantial likelihood that an identical process has been made by the patented process, and the patentee has been unsuccessful in spite of reasonable efforts to determine which process was used to prepare the प्रोडक्ट. सो अगर ये सब अगर पैटेंटी दिखा देता है कि देयर इज अ सब्सटैंशियल लाइक्लीहुड कि जो प्रोडक्ट डिफेंडेंट का प्रोडक्ट है जो बिल्कुल उनके प्रोडक्ट की तरह है वो पैटेंटेड प्रोसेस से ही बना है, और उन्होंने बहुत कोशिश करी जानने के लिए कि कैसे प्रोडक्ट प्रोसेस से बना है पर उनको नहीं पता चल पाया, then the burden of proof shifts on the defendant to establish that the process that they are using is different from the process that the patentee is claiming to be patented. Now, what are the defenses in the case of infringement suits? The defenses in infringement suits are defined by Section 107 of the Patents Act. And सबसे पहला defense ये है कि आप बोलें कि जो patentee का the patent है वो valid ही नहीं है. So that is a counterclaim for invalidity of the patent. या फिर there are certain acts which do not amount to infringement. For example, अगर आपने patented product या process को एक्सपेरिमेंट्स में यूज किया, रिसर्च में यूज किया, या टीचिंग पर्पसेस के लिए यूज किया फॉर इम्पार्टिंग इंस्ट्रक्शंस टू पीपल, देन इट इज नॉट एन इन्फ्रिंजमेंट. अगर गवर्नमेंट यूज के लिए था आपका जो भी आपका यूज था, दैट वाज इन परसुएंस टू ऑर्डर्स ऑफ द गवर्नमेंट और इन परसुएंस टू डायरेक्शंस फ्रॉम द गवर्नमेंट, देन अगेन इट इज अ डिफेंस टू इन्फ्रिंजमेंट. Other than this, there are certain acts which are not considered infringement, and these are provided by Section 107A of the Patents Act. The first provision is the Bowler provision. Bowler provision means any act of making, using, or selling it, or importing a patented invention solely for the purpose of developing information which is required under any law for the time being in force that regulates the manufacture, construction, use, or sale or import of any product. So basically, for example, इसके लिए सबसे कॉमन एग्जाम्पल होता है मेडिसिन का, जहाँ पे एक पैटेंट है which exists on a medicine, and there are several generic manufacturers who are looking at launching the product in the market once the patent expires. पर जेनेरिक मैन्युफैक्चरर भी सीधा अपनी मेडिसिन को लेके मार्केट में कूद नहीं सकता है, उसको कुछ अप्रूवल्स की जरूरत है, तो वो पैटेंटेड प्रोडक्ट को यूज कर सकता है फॉर डेवलपिंग इंफॉर्मेशन टू गेट रेगुलेटरी अप्रूवल्स. This is the Bowler exemption. That kind of use is allowed or is permissible under the law, and this will not be treated as infringement. If you have used the patented product or process to arrive at a product, to gain information and to obtain approvals under any law for the time being in force in India, that will not be treated as an infringement. Then there is another provision which is called as parallel import. Parallel importation is based on the principle of exhaustion of rights. So basically, parallel importation is where you are importing a patented product into the country from a person who's authorized to sell. मतलब कि जैसे इंडिया में एक कंपनी ए किसी ड्रग को 100 रुपए में बेच रही है, पर बांग्लादेश में वही सेम कंपनी ए जो कि पैटेंट होल्डर है उस ड्रग को 50 रुपए में बेच रही है. नाउ आई वांट टू, कोई इंडिया में पार्टी है बी, वो बांग्लादेश में उस ड्रग को खरीदती है फ्रॉम द पैटेंटी एंड इंपोर्ट्स इट इनटू इंडिया एंड सेल्स इट एट 70 रुपीज. तो पैटेंट होल्डर ये नहीं कह सकता कि उसके राइट्स इन्फ्रिंज हुए. क्यों? क्योंकि इस पर्सन बी ने सबसे पहले पैटेंट होल्डर से ही वो ड्रग बांग्लादेश में खरीदी. सो देयर इज एग्जॉस्शन ऑफ राइट्स. पैटेंट होल्डर हैज ऑलरेडी सोल्ड द प्रोडक्ट टू द इंपोर्टर. They have already sold the product to the importer at a lower price in Bangladesh. Once you have sold your products, you do not have any rights over those products. You've already claimed whatever rights you had in that product by selling it over. Now the importer can sell it off at any price in India. So this is the principle of parallel import, and it is based on the principle of exhaustion of rights. And doing something like this, where you are importing from a person who's authorized to sell the patented invention, will not amount to an infringement. So this is Section 107A of the Patents Act. What are the reliefs that you can get in case you are able to prove an infringement? In case a patentee is able to prove an infringement, The first relief is, of course, an injunction. The offending party will be injuncted from carrying out the offending acts. And at the option of the plaintiff, you can either get a damage or an account of profits. You can get damages or accounts of profits. You could even get costs. And the court could also order a seizure or forfeiting or destruction of infringing goods or any substance or implements that are being used for the production of infringing goods. So with that, I end my talk here. Hemant, if you have any questions, please let me know.
Okay, ma'am. So, ma'am, Himani Hajela wants to ask that face recognition, which generates different results using AI algorithms on Facebook and Instagram, can a patent be granted as artificial intelligence is not a neutral person?
See, I think that's a big debate. In fact, the European Board of Appeals is now going to issue a big decision in a few days regarding whether artificial intelligence can actually be a legal entity. And so far, things are not so much in favor of artificial intelligence being treated as legal entities who can go and actually apply for patents. So again, India hasn't faced such a debate yet. We haven't seen any such case happening here. But yes, so far we haven't seen any cases where, in fact, recently there was a case in the US where such an artificial intelligence applicant was not granted a patent.
So, ma'am, coming on to some questions which are not very technical. So, ma'am, the questions involve like what are the opportunities for people who are trying to pursue their career in patents after this COVID situation? So, ma'am, will it be hampering them or will it be providing them opportunities?
See, COVID situation, and I think I just discussed this with Hemant sometime back before we started our talk. It is a blessing in disguise, I would say. It is a difficult time, no doubt. And this is an uncertainty which none of us could have seen. But all of us have learned so much during this period. For example, being reconnected is one thing that has really come in big time. And there are a lot of firms who are offering e-internships. So I think all the law students should take advantage of this. And now you don't even need to be physically present in a particular city to be appearing for your internship. You can sit in any part of the country and do internships in as many firms as you want, all at the same time. So maybe that is something that can be tapped. At present, of course, the COVID-19 scenario, as you know, is affecting a lot of realms, socio-economic realms in the country. But then that is not to say that this is going to be a permanent embargo to, law students or people are not going to get opportunities. I'm sure there are going to be ample opportunities as soon as the situation opens up. Even now, there are opportunities springing up here and there in spite of these difficult times. It may take time, but of course, things are going to get back in track.
Okay, so ma'am, do you think that the restrictions of patents can create an hindrance while finding a solution for this COVID-19 thing? Because pharmaceutical companies will be facing problems with this.
Pharmaceutical companies will definitely be filing at this point of time, and I'm sure there are a lot of patent applications which have already been filed relating to the COVID-19 scenario. As I said, there are certain things. For example, if you are claiming a new use of a known compound, so if you're using the treatment of COVID with an already existing drug in India, you're never going to get such a patent in India. But if there are novel patents, etc., you are definitely going to get a patent and nothing will stop you. Because in fact, this is like something, because this area does require a lot of research. Imagine if there is no research at this point of time going on. Do you think we are going to get a cure anytime soon? No. So research is equally important, but then that research needs to be incentivized. Otherwise, who keeps doing work for charity all the time? You need to have your belly full to even to do anything. So yes, there are going to be challenges, but then I do not think that would result in non-grant of a patent. They will result in grant of a patent if your invention satisfies the criteria under Section 3 and the novelty, inventive step, and industrial utility criteria. There is definitely going to be a grant, but then how that is going to be enforced is going to be the question. Because you may, this is a scenario where you may even see innovator companies themselves offering licenses to local partners in India to make the invention available to masses. So either there will be a lot of voluntary licensing or there will be compulsory licensing. The times are yet to come, and we'll see on that. But then I do not think that's going to prove an embargo to grant. It's going to be the enforceability that's the question.
Okay, ma'am. So, ma'am, considering that the most of the people who are viewing us today are law students,
Yes.
and so, ma'am, what will be the final advice that you want to give to them?
The advice, okay, the advice would be because we are living in these uncertain times, I would say, and as I just said, that we should take advantage of this. We all of us and a lot of law firms, we have switched into the e-internship mode. You should keep applying into all these internships. Pursue as many courses as you can during this period because you are saving a lot of time on commuting here and there. You are actually not going out so much. So we have a lot of time in our hands, right? So maybe we should pursue more courses, seek more e-internships, make the best that you can during these times, and be hopeful because though this is a difficult time, it is going to pass.
Okay, ma'am. So, ma'am, in the end, I would just like to say that hosting you was really a pleasure for me, and it was a wonderful experience listening to you, not only as a moderator but also as a viewer. Moreover, ma'am, it was an honor for the whole team of Spread Law and Legal Sarcasm that you managed to take out time out of your busy schedule for us. So, ma'am, thanks a lot. And for the viewers, like always, I say that stay tuned for more webinars and like this, and follow up us on social media platforms, and we'll be definitely meeting you soon. So, ma'am, thanks again, and
Thank
thanks
you,
to
Hemant.
everyone.
Thank you for your kind words.
Yes, ma'am. So, ma'am, thanks a lot for joining us today.
Thank